Today, we're going to dive into a fascinating aspect of South Africa's legal system, how it blends Roman Dutch law, English common law, and customary law. This creates a unique and complex legal framework that might be quite different from what you're used to if you're studying in jurisdictions rooted solely in common law or civil law traditions. Roman Dutch law, which is the foundation of South Africa's private law. Roman Dutch law is a hybrid legal system that originated in the Netherlands, combining Roman law principles with Dutch local customs. It was heavily influenced by the classical Roman law that shaped the legal thinking in Europe. In South Africa, Roman Dutch law forms the basis of civil law, everything from contract law to property law. However, it's not just an ancient system. It was adapted and modernized as South Africa moved through its history, especially during the colonial era. Next, we have English common law. This legal tradition was introduced to South Africa during British colonial rule, and it has had a significant impact on the country's public law. English common law focuses on judicial decisions and precedents, meaning that past court rulings are often used to guide new decisions. This is particularly noticeable in criminal law, procedural law, and constitutional law. For example, South Africa's criminal justice system and trial procedures align closely with English common law practices, including adversarial proceedings and the role of proceeding in judicial decisions. Customary law is another key component of South Africa's legal system. It is the body of law practice in communities, particularly in rural areas, and is based on the traditions, customs, and practices of indigenous people. Customary law plays a significant role in family law, inheritance, and land use in certain communities. In fact, South Africa's constitution recognizes the legitimacy of customary law as long as it doesn't conflict with human rights principles. This makes South Africa's legal system more inclusive and reflective of its diverse society. So, how do these three legal traditions blend together in South Africa? Well, it's a fascinating fusion. While Roman Dutch law is used in private law, English common law influences public law and judicial processes. Customary law, on the other hand, ensures that indigenous practices are respected and integrated into the legal framework. This blending process can be complex and, at times, challenging. For example, when a case involves both Roman Dutch principles and customary practices, courts have to strike a balance between them, ensuring that neither legal system trumps the other.